Hey, everybody. Welcome to our very first Wednesday Night Live. Thank you so much for being here. We appreciate you taking the time on your Wednesday midweek evening hump day to join us to talk a little bit about true crime news. The reason we wanted to do this is the concept behind this is that we wanted to have kind of a midweek check-in, but that it wasn't like our produced show from Fridays. On Fridays, I don't need to bore you guys, but we put a lot of work and effort into that. It's, researching the cases, finding the cases, putting together the clips, editing everything together. The turnaround on it is a lot of time. And we thought, well, we want to continue to add more to the channel. We want to have more content. We want to be able to give our members more value for being involved and supporting us. And instead of trying to add yet another one of those produced shows, we thought, you know what, let's just do kind of an informal midweek check-in. So that is the concept behind this. So from this Wednesday, moving forward, and hopefully every single Wednesday, meet us here at this same time. Maybe we'll change the time a little bit earlier or later. That's the great thing about doing this kind of media. We don't have to deal with contracts and everything else. But we think this is a good time for everyone that they're hopefully getting off of work or have some time to check in with us. And we're going to talk about some cases, but we're also going to let you direct it. If you have questions, please leave them in the comments. If there's a case you want to talk about, please leave it in the comments. Hopefully I know enough about it that I can talk about it with some education behind it, and you guys can feel like you're learning something. But I do have some things prepared. We're going to talk a little bit about Alec Baldwin and that whole mess that never seems to go away, a little bit about Bryan Kohberger. Maybe we'll get into Donna Adelson and Carly Gregg. A lot of stuff that we can touch on. We don't need to touch on all of it, but we'll try to answer questions, talk about these cases, and see where the whole conversation goes. That is the concept. I hope it works. I appreciate you guys being along for the inaugural ride on this whole thing, and we'll see if we have some fun with this. Some personal news to catch you all up on, if you haven't heard already, and the reason why this is our second attempt at being our first Wednesday Night Live is I had, and my whole family had, a hell of a couple of weeks. And it started with, if you don't know, we had been expecting our first baby, or not our first baby, our third baby, but we were expecting her to come any day now. And I had planned a trial to start at the beginning of the month so that I got it clearly out of the way before the baby came. Well, the baby, in typical Ritter fashion, has been very impatient and decided she wanted to come early. So my week consisted of last Friday, the Friday before this last one, I finished a trial. It went very well. Thank you very much. Got that out of the way. Thought I would have some breathing room and time to get my life back together. If you've ever been in trial or involved in trials or know anyone who does trials, it just turns everything upside down. Then by late Tuesday night, my wife turns to me and says, I think it's happening. I think the baby's coming. And we start scrambling around to find people to come because we've got two older little ones in the house and they were sound asleep, and we're making phone calls trying to get people to come over to help us watch those kids so we could run to the hospital. No one's picking up their phones. It's 11 o'clock, 12 o'clock at night now, and we're starting to panic. So I tell my wife, well, you need to get to the hospital because we're not having this baby here. You go ahead and get in the car before, your contractions start to get unmanageable. Make it to the hospital, and I will figure out getting someone here to watch the kids and come join you. So luckily, one of our babysitters, who's a college girl and she's fantastic, answered her phone at around 12:30 at night. She was remarkable and a hero, and she said, I'll be there in half an hour. So by 1 a.m., babysitter shows up. I hop in the car. I go to the hospital. Wife is already getting prepared. And by 4 a.m. that morning, we had our third baby girl named Remy. And we're very happy and very blessed. And mommy and Remy are both happy and healthy. And that's all that we could ask for. So she came a little bit early. She was born at 4 a.m., Jody, or 4:17, something like that. I'm sure my wife's going to be upset. I don't know the exact time, but it was just about a quarter after the hour, 4 a.m. And mommy's healthy, baby's healthy. We're completely blessed. Her name is, like I said, she's a little bit smaller because she still had a couple of weeks, I think, to bake. But we're happy that she's here early. Her name is Remy Jacqueline. And Jacqueline is kind of an homage to my father who passed. His name was Jack Ritter. And so we thought that that would be a good way to kind of send some love his way. Thank you, Jay. Thank you very much. We're very, very happy. So because of that, well, we can't do our Wednesday night live that night. So we sent out some quick apologies and let you guys all know that we had a pretty good reason, I think, for missing that. So here we are again, attempt number 2 at doing these Wednesday night lives, and a lot going on in the Ritter household. But everybody's managing, you just deal with it and take it one day at a time, and everybody's getting the love and attention that they need, but maybe not as much as they want, but we're all very, very happy. Okay, so that's what's been going on with me. I wanted to welcome everybody to the chat. Some of you checked in already. I'm recognizing a lot of names and familiar faces. Thank you so much. If you guys haven't already, please subscribe so you can be a part of more of these. Quick kind of thank you to some of our new members, because we did start a membership program and the response has been phenomenal. And we're so grateful to all of you folks. And if you want to learn more about it, you have to actually either click on the link that we're going to have connected to this video, or you have to actually go on the website page, because you can't do it from your mobile device because, Apple is fighting with YouTube and it all doesn't work out. But to some of our new members, Gen X to the 7th Power, Jade Roscoe, Barb Pace Lamb, Canine Catherine, Girl Ryan. Oh, my oldest daughter's name is Ryan. Seeking Justice, and As a Matter of Fact. All of you are phenomenal for jumping on board, and you help support the channel, and we're very, very gracious to you for that. So I see a lot of congratulations from everybody in the comments. Thank you very much. All right, let's jump into what is happening with poor Alec Baldwin. Never thought I would say that, but poor Alec Baldwin at this point. I like Alec Baldwin. I think he's a good actor. One of my favorite movies is The Hunt for Red October. Thought he was great in that. Very young man way back then. Thank you so much, Jay. His personally, it's not like he's like some huge celebrity that I'm rooting for, but I'm getting to the point where I kind of feel bad for this guy because of this prosecutor, Carrie Morrissey, seems to have lost her mind over this man. She has completely become obsessed with getting Alec Baldwin, and it makes no sense to me, and certainly not on a case like this. So let's talk a little bit about what she is doing now. You guys all know this case, but you remember Alec Baldwin's an actor. He's holding what he believes is a prop gun. He pulls the trigger on that gun. He says he didn't. I think we all can agree he probably did, thinking that nothing would happen, like he's done with 100 guns on 100 different movie sets over his career. And the gun tragically goes off and takes the life of this poor cinematographer, Helena Hutchins. Tragedy, awful. Bunch of people can be held responsible and probably should pay a ton of money. But now the state of New Mexico decides that they're going to go after him criminally. And that's where I start to raise my eyebrows, because Criminal liability is very different than civil liability. And now you're trying to say that it's not just that you did something negligent and stupid. You're trying to say that you did something so indifferent to safety and other people's humans' lives that we're going to hold you criminally responsibility, meaning we're going to put you in jail, by the way, which they've already done with the armorer on this case. They're willing to put people in jail over this. So now we've got Alec Baldwin, the actor. And as you all know, if you followed it at all, we did a whole episode on this channel about it. Thank you so much, Joanne. Thank you so much, Jay. The case fell apart phenomenally because of an issue about turning over evidence. And you're absolutely right, Jody. It was dismissed with prejudice. Prejudice meaning prejudging it, meaning I am deciding already you don't get another bite at this apple. And we're going to get into that and why it is that they're even bringing this motion. But the issue in a nutshell as to why it was dismissed is the judge just felt the prosecution has a responsibility. As a prosecutor, I understood this. Thank you so much, Pammy. Thank you. I understood this as a prosecutor. My job is not to decide what evidence is good for the defense and what is not, what is useful to them and what is not. My job is just turn it all over. Now, that doesn't mean I have to go on wild goose chases and chase down every single ridiculous lead. But if I have the evidence, if it's handed over to me, if my investigators have found it, I got to turn that over. I am the steward of the evidence and I should just turn that over and just make everybody's life easier. If I feel it's irrelevant, I bring that up with the judge at the time of trial and we say, hey, this is irrelevant and they shouldn't get to admit it. But that doesn't mean that the defense doesn't get their hands on it. This case was dismissed because the prosecutor made a decision that the evidence was not important. Now, here's the strange part. She might be right. She might be right that it wasn't all that important. She might be right that the bullets that were turned over were not really germane to the issue. And we're going to get into probably the only salient fact she makes in this entire argument, or the only salient argument she makes in this entire motion dealing with that. But that's not the point. The point is turn it over and deal with it later. Let the judge decide what's coming in or what's not. Now, the judge kicks the case, calls it a discovery violation, calls it a Brady issue, kicks the entire case, and with prejudice, you're done. And we all saw Baldwin in court, and he's crying tears, and they're hug, hug, kiss, kiss, goodbye. Justice is done. He's on his way. Not to Carrie Morrissey, not to this lady. She is certainly not done. And she should have swept up what little bit of dignity she had left, packed up her bags, and just rode off into the sunset. But instead, she decides she's going to give it another go. And by give it another go, I mean that she files a, get this, 52-page motion with an additional 387 pages of exhibits. This isn't a, hey, judge, I'd like you to take another look at what you did now that the dust has settled. This is her magnum opus as to why she feels the judge needs to undo what she did. Do I think she's just trying to redeem herself? If she is, she's got nobody helping her out and telling her that this is not redeeming her. This is just making her look more ridiculous. And we'll get into why that is. I read this thing. It is a fever dream written by Don Quixote. That's what this is. This thing reads like someone's like a breakup email. Like you broke up with someone and then you're going to air all of your grievances in some sort of 2 a.m. alcohol-fueled email. That's what this whole thing reads like. And we'll get into some of what I think are the highlights of this whole thing. But the reason why I'm so kind of jacked up about this is not that I think it's got a snowball's chance in hell of actually being granted by the judge. And she didn't grant it. And we'll talk about why she didn't grant it. but because it bothers me as a former prosecutor that a prosecutor has made things so personal and taken it upon herself to just, I don't know. I mean, you have a great responsibility as a prosecutor, and that doesn't include personal vendettas, which this is starting to look like to me. Okay, so let's see. This is part of the motion. And I just wanted to highlight this first little clause here, because I have never in my life seen this in a motion written by a prosecutor. And she starts out by saying that Miss Popple, who was the investigator who, not to get into all the weeds as to why this whole thing was, but she is the one that received the live rounds that became the whole issue. They were turned over by this person named Teskey. Miss Popple made a mistake because she had not viewed the live rounds turned in by Teskey in several months. And there are thousands of live rounds, live, blank, and dummy, of ammunition in evidence in this case. Then here's the kicker. Human beings make mistakes. It does not mean they are lying or they intentionally buried evidence as claimed by the defense. If you are writing the phrase human beings make mistakes in a document as a prosecutor representing the government, you already know that this is off to a bad start. But fine, she's saying, listen, it was an error, it wasn't intentional. Okay, you want to make that clear. Here's the part though that she's saying where she actually begins to address the issue, because the issue is really, did they turn it over and why didn't they turn it over? And something she kind of avoids, why was it put under a different case number, is probably the most offensive at all. But she says, it simply didn't occur to the prosecution that the live rounds were relevant to the case against Baldwin, even if they were the same or similar to the live rounds found on the set of Rust. I don't even know where to begin with this. She's saying they're similar or the same, but she's saying even if they were, it didn't occur to us that they were relevant. And that, I think, really, in a nutshell, explains why the judge did what the judge did. The judge, I think, was really making a ruling based upon the prosecution's behavior and the prosecution's limping into this case, a weak case to begin with, on a very, very weak theory as to criminal liability. And the judge, I think, was just having enough. And this idea that it didn't occur to the prosecution that they were relevant, that's not your job. Relevance is a judge's decision. The judge decides if it's relevant. If it's evidence and somebody turned it over and tells you that it has to do with the Rust case, then you tag it and bag it and turn it over to the defense. You don't decide for yourself what's relevant and what's not. You are not the one in the black robe. And that's the part that I think the judge in this case really made their decision based upon. Okay. She goes on, some other highlights here. Again, I'm not going to go through this entire thing because it'll make us all want to pull our hair out. But just some stuff that, just as I was reading it, I highlighted because it offended me. She's saying she's incompetent. Almost, right? Afton, it almost sounds like she's admitting her own incompetence. I didn't realize it was relevant. Again, I don't care what you realize, lady. Your job isn't to realize stuff. Your job is to turn it over and let the judge realize. Then she goes on to say, the state was represented by two attorneys that did not have the human resources to respond to a motion to dismiss and prepare for the next day's witnesses in one evening. I just highlighted this because she points out how he's got this entire team. They're just two attorneys working on this, and they weren't able to reply to things in the way that the judge had hoped that they'd be able to reply to them. Horseshit, lady. You don't, as the government, ever get to make the argument that you are somehow outgunned. I don't care if he's got an entire team. You've got the power of the entire government behind you. And I worked in the government, and I get it. And I understand that, yeah, they are not sometimes supplied with the same resources that you might think that they're supplied with. And yes, sometimes it is just me and a couple of volunteer law clerks as a prosecutor working on a case. But you don't ever get to put that in writing, that somehow you as the government trying to put a man in prison, we're just doing the best that we can here on this shoelace budget of ours. Again, horseshit, lady. Come on. You're trying to put somebody in prison. If it's too much for you and you're not up to task, then don't go for it. But you don't get to plead this kind of it gets me riled up because it's offensive to me. These arguments are not arguments even toward her motion. They're arguments as kind of like pity arguments. It's almost like I should have a little bit of sympathy. I didn't realize, I didn't know. She made a human mistake. We're outgunned. We don't have enough people. And then she goes on to say, the defense knew, here's this one. The defense knew that some of the rounds turned in by Teskey were the same or similar to the live rounds from the set of Rust, and laid in wait to move to dismiss during trial when it had a tactical advantage. The defense laid in wait. Good on the defense. That's called strategy, lady. That's called doing your job right. If you didn't know this stuff ahead of time, bad on you. But don't say bad on me, because I represent someone that you're trying to put in prison, and I strategically waited until an ideal moment to spring this on you. And during trial, when I had a tactical advantage, the tactical advantage supplied by me because you weren't doing your job properly. That's what she's saying here. It's just, again, as you go through this, and do yourselves a favor, don't read this thing. Don't read it. The judge didn't even read it, by the way, as we're going to get into, for the reasons why she actually denied it. She denied it based upon the page number, by the way. Not to hide the ball here. She denied it because it was just too long. Let me see. Then she gives us a little bit of foreshadowing of things to come when she says the state respectfully requests this court order the defendant to provide all information regarding when and how they learned of the Teskey rounds. Not, by the way, not something that should be ordered. Not can't and shouldn't be ordered. Not your business of when they learned of things. They're the defense. They're allowed to go out and collect evidence and do their job. They're not that you're not entitled to know when and how they did something, because that's not important to you. It's them doing their job. You do your job. Does this motion go to the same judge that dismissed it? Yes, it does. It goes to that same exact judge. But great question and good timing, Jody, because this is what she's actually setting up here. She says, we would like them to, when they learned of the rounds, to the court and to the state, so that a full record can be made for the likely possibility of a review by a higher court. The state is entitled to a full record for appellate review. That is the shot over the bow. That is, I'm going to appeal this whole thing, by the way. And that's the point of this motion, really. The point of this motion is to get a denial so that she can appeal it up. And yes, you usually cannot appeal things. You cannot appeal an acquittal, but you can appeal a ruling by a judge. And that's what she intends to do here. Where, by the way, this under-resourced, her and just her coworker and a hamster running on a wheel in a back office of, on the underground of the New Mexico DA's office. And she's so understaffed. Where is she getting all the time and resources to put the energy into doing all of this, by the way? Why isn't she just, like I said, swept up her dignity and went on her way? Take the L. Sometimes you have to as a prosecutor. Is she independent or employed by the state because the state should kick her to the curb? That's a great question. I'm not sure, Melinda. I know she is, quote unquote, a special prosecutor, but I don't know how the funding all works. And I'm going to look into that. So this right here means that it's not over. And I'm going to make your life miserable, you, Mr. Baldwin, and everybody else who's been following this case, because I'm going to continue to bring this up yet again when I bring this up for appeal. Now, let's get to the actual one point that she made in here, which I thought was was good, but why she doesn't understand why the judge kicked this out. It's this one line here. This is on page 39, if you're following along at home. It says the case against Mr. Baldwin was solely based upon his actions when the gun was in his hand. And that to me is true. That is true. It is true that these bullets really are not really here or there when it comes to why the case was dismissed. This whole thing comes down to what he did when he was holding the gun and what was going through his head. That's an excellent point that she makes. But what she misses is what she then says a few sentences later here. It never occurred to the state that Teskey's rounds were relevant to the case against Mr. Baldwin, and they are not. Here's where she, in one sentence, you can tell what she doesn't understand. They are not. They are not. That's an argument. Fine. And leave that up to the judge. Are these relevant? Probably not. I'm going to go ahead and say they're probably not relevant to their theory of the case. How did the bullets get there? Really don't have to do with what they're accusing him of. Now, I don't think they should have been accusing him of it to begin with, because I think it was a very weak case to try to say that an actor should have known better than to be handed a gun, told it's cold, and acting in a scene. I know some people feel differently about that, but if that's the theory they were going with, then where the bullets came from is not really part of their theory, because he had nothing to do with that. So they're saying that those rounds are not relevant. Okay, fine. They are not, but it never occurred to us whether or not they were relevant. That's the problem. It's not on you to be occurring or not occurring to you. It's on you to just turn it over. A lot of people's wasted time to expect a judge to listen. Yeah, I agree with you. I think it is just her kind of airing of grievances, like I said. And it reads like that. And then at the end of the day, when all is said and done, when you get through all 52 pages of the whole thing, she doesn't have a leg to stand on legally. There's no authority cited for what she's asking the judge to do. She's saying it's a motion for reconsideration. Motion for reconsideration basically means I would like you to think about what you did, Your Honor, because I'm not happy with what you did. And I'm asking you to please take another look at it now that now that the moment has passed and we've all had a chance to take take a breath. Josh, does Carrie have her own law firm as a defense attorney? I don't know that either. I'm not sure of her status, and I will look into that for sure. But my point is, a motion for reconsideration is a long shot to begin with, but if you're going to do it at all, at least have some solid case authority for why you're asking to do it. Say, based upon this Supreme Court case, this state Supreme Court case, I am entitled to have you sit in review of your own ruling, essentially, Your Honor. Sit in review of your own ruling and take a moment to reconsider what you've done, because I don't think you made the right ruling. And here's all the case law that I wasn't able to present you with at the moment that will help you to understand that. She doesn't do any of that. She just airs a bunch of grievances, makes a bunch of kind of sorry sack apologies and woe is me arguments, and then says, you got it all wrong. I still think that it wasn't relevant. We didn't realize it was relevant, and therefore we want you to redo it. And what we want you to redo is bring this man back to trial, to stand trial, that he may possibly go to prison. Not going to happen, lady. Not going to happen. And the judge denied it. And the judge denied it, I think, for the most awesome of reasons. The judge said it's too long. It was 52 pages long. You're entitled to 10 pages. You went over that by 42 pages. I'm go ahead and just deny this out of hand. And to me, what that really is the judge saying, I've had enough of your crap, lady. I've had enough of it. Please stop. I gave you one shot. You made your arguments. I heard everything that you said in court, and you didn't say anything that convinced me. And I'm not going to go ahead and waste my time reading 52 pages like Mr. Ritter just did and entertain everything that you just had to say. Then in typical Morrissey fashion, and I'm not trying to bash this lady. As a former prosecutor, I'm bashing a prosecutor, I think, not representing that position well. But in typical fashion for her, she goes back and says, well, I would like you to reconsider not considering my motion based upon the page limit. And the judge says, and I got the quote here and I wanted to read it for you all because I thought it was great. The judge says, briefs that exceed page limits, even when this court has approved the additional pages, are almost invariably unpersuasive. Meaning, if you can't convince me in 10 what it takes you 52 to do, I doubt that you have a very convincing argument. And I tend to agree with that. This issue isn't all that complicated. Really, it really comes down to, why didn't you turn some stuff over? And you don't need 52 pages to explain that. What she tried to do is take 52 pages to explain why she made the original decision not to turn it over, which is not the point. She's again missing the point. The point is, you didn't turn it over, not whether or not it's relevant. That's me, the judge in the black robe, the one sitting up high in the courtroom. That's for me to decide. What you need to do is explain why it wasn't turned over. And simply saying, I didn't think it was relevant, is not going to cut it. And that's what she took 52 pages to do. So that's why we're sitting here today talking about this lady and why it's wasting all of our time. All right. Let's see if we've got any questions before I move on to the next bit of nonsense. We've all had enough of her crap. How is she still employed as a special prosecutor? I do not know. That's a great question too, because you would think that her retainer, her employment, would have ended with the end of the case. And, I'll say this though. Even before she was involved, this case had a really weird history in New Mexico where they were really, you remember from the get-go, this isn't like the first time that they've had a mess up with this prosecution team. There was, originally they filed the case, or they announced that they're going to file charges. You remember that? First of all, the investigation took like a year. Then they announced that they're going to file charges. Then they go on this media campaign, never seen before in my life. They're doing the morning shows, for God's sake, before they charge this man. Then they charge the guy. Then they realize one of the allegations they've charged him with, the law didn't apply at that time. So then they got to dismiss that. Then there was some issue about whether or not the DA could also work alongside the special prosecutor, and they asked to have her just again and again and again. I did a whole video on this if you guys want to see it, leading up to the trial, because I thought the trial was going to last longer than it did, where we go into the entire history, tortured history of this whole thing. And to me, it showed a prosecutor's office that was working off of a vendetta, way over their heads, and really behaving in a way that I thought was not becoming of the office. And just says, can she be disbarred? I don't think so. Nothing about what she's done, I think, is so clearly a violation of ethics. I think she will have to report the discovery violation, the potential Brady violation of not turning that over, but I don't think they're going to disbar her for it. She might get a talking to, they might open up an investigation, but it's unfortunate that getting an attorney disbarred takes an awful lot. You see a lot of, unfortunately, really bad attorneys who are continuing to survive out there. So beware who you hire. All right. Should we move on to talk a little Kohberger? Because this one was also interesting to me. Let me see if I can pull up the Kohberger brief so that we can go through that as well, because I thought that one was one worth looking at. Let me see if I can do this. Bear with me, guys. Sorry, still getting the hang of this. All right, here's the Kohberger motion. So just to give you the background on Kohberger and what's happening in this case, you guys all know this is the awful case about the stabbing of 4 University of Idaho students in Moscow, Idaho. And the last issue that kept on coming up again and again and again was the idea of a change of venue. And the defense was saying this case is getting so much publicity in such a small community that there's no way he can get a fair trial here. And I will tell you that I did not like this argument to begin with. I'm not necessarily against a change of venues. I think sometimes they're appropriate. And in fact, I think they're appropriate in cases involving a small community where most of the community knows something about it and that there's going to be a bias against the person. Let me just make sure I got this all set up for you guys. Okay, here's the Kohberger. We'll talk about it a little bit first. But I'm just going to say that I've worked on a few high-profile cases in my past. I mean, one of the first cases I ever worked on in my career was the Phil Spector prosecution. I was Alan Jackson's law clerk on that case. I've talked about that a couple of times. And that case took place in Los Angeles, and we handled it in Los Angeles. And it was a case that got a lot of attention, and it was on TV every single day, and everybody, you would think, knew about it. What you find, though, is you get people into court and you ask them, hey, do you know about Bryan Kohberger? And they say, oh yeah, I've heard the name. I know about the case. Well, do you have any feelings about it? No, not really. Well, how much news do you watch? Not much at all. Well, do you watch anything? What do you pay attention to at night? I follow my kids' little league team. I follow the Cubs. I follow, the Real Housewives of wherever. They're more in tune to these other things and these true crime stories that for us in this world that kind of occupies us, and we feel that you have to know what's going on in this. They're not really following. I'm sure you guys have experienced that. I'm sure that you've talked to people about, oh my God, did you see what's happening in the Donna Adelson case? And your coworkers, your friends, your family go, I don't have any idea what you're talking about. I get that all the time from my friends who are also defense attorneys. I'll talk to them about, oh, I'm doing a podcast on this such and such a case, and they have no idea what I'm talking about. And I'm talking about cases that have national headlines. So my point is, just merely because a case gets a lot of media attention, I don't think that alone is a good enough reason to ask for a change of venue. I'm thinking it won't matter where the venue is changed. It's a nationally known case. That's another good point, Jody. If this is such a huge case, is there really any place that you can put it? Because again, and we're going to get into this, the standard isn't, have you heard of it? The standard is, do you have a bias about it? Okay. So anyhow, I'll say 2 things on this. One, I'm not entirely thrilled with the reasons for it, but 2, I agree with the judge doing it, and I'll tell you why at the end. But it's not entirely for the reasons that the judge puts in here, okay? So the judge goes on to cite a bunch of experts that were called by the defense who, tried to enlighten the court on how, in fact, this was affecting the community. And one of the things the judge says is that one of these witnesses, this is James Todd Murphy, comes to the conclusion that all of this taken together means that the probability of Aleda County, which is where this would be tried, where Moscow is and where the university is, where the murders took place, that of a Aleda County resident being exposed to media coverage of this case is much higher than the probability of an Ada County, where Boise and the hub of the state is, residents would being exposed to media coverage of the case. Okay, so the point is, it's probably more likely that in this small town community where the college is a big deal and where the murders took place, they're going to know about it instead of in Boise. Okay. Not a point that I even think you needed an expert to be called on, but okay. That's a point, not a point to actually change venue, but that's a point. Okay. Page 6 here. This is another expert saying it. Now this gets a little bit more ridiculous. His opinion, Dr. Alayi, opined that it was arguably impossible for residents of Leda County to be asked to serve as impartial jurors because they are biased against Kohberger, even if they do not want to be biased or think they are biased. And this is where I really started to get bothered, and I feel like the defense arguments kind of took off the rail here, because they're basically trying to say that this is so pervasive that there's no way anyone in that community could not be biased, and that everybody knows about it and everybody's already made up their minds. And even if they tell you that they haven't, then they can't be believed because their bias is somehow unknown to them. And so it's just this kind of overextending, overly broad argument that there's never going to be any way that you could possibly get a unbiased jury in this whole county. Okay, let's kind of put aside all of these arguments and the evidence, quote unquote, that the judge says. The standard that the judge cites is this, and this is pretty straightforward. If the court is satisfied that a fair and impartial trial cannot be held in the county where the case is pending, the court may transfer. The court may transfer the proceedings to another county. Here's the whole sentence. The court may transfer the proceedings to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Pretty low standard, actually, when you think about it. I mean, that's not that high of a standard, and it's really just up to the judge entirely. Okay, so that's what we're dealing with as far as what the judge is trying to make his decision on. He goes on to say that the critical inquiry is whether the nature of their exposure to pretrial publicity called the prospective juror to form an opinion about the defendant's guilt, and as a result, they are unable to serve as an unbiased juror. That is the standard. And you notice that is different than saying knew about the case. But did this pretrial publicity cause them to form an opinion? And that's the whole point. Even in these high-profile cases, you get people through the door. Harvey Weinstein was tried here in Los Angeles. That case was known all over the country. This is the poster child for the Me Too movement. Everybody knew Harvey Weinstein. But you get people who come in and the question is asked, not do you know, not have you heard, not have you read, not have you seen some TV documentary or some TV expose, but was it enough for you to form an opinion that you are unable to serve because you're so biased upon the opinion that is built within you? And that to me is where I think I begin to question the reasons behind what the judge provided as the reasons for moving this. Again, I know I'm kind of teasing the payoff here. He talks about actual prejudice. He says actual prejudice doesn't actually exist because we don't know. We never heard from the jurors, so we don't know if they're actually prejudiced. But then he goes on to this presumed prejudice. The judge asked to be removed. The judge, by the way, do you ever live your whole life and not become a judge if your actual last name is Judge? I wonder if that guy even wanted to go to law school, or if it was just your last name is Judge. This is what's happening. But Judge did, part of his ruling was that it would be assigned to a different judge. That is correct. He's done with it as well. I don't think that played a role, but I think that absolutely was part of the decision. If we're moving it to another county and you're just going to deal with a whole new crew down there. Then he goes on to talk about this presumed prejudice. And presumed prejudice to me is where things become dicey, because it's like, what does that mean? Well, what it essentially means is that because this is a small community, because there was so much TV coverage of this, we can essentially presume, like that person was arguing, that expert was arguing, that no one here can be unbiased, which to me is a little ridiculous. So here's the court's final decision, or the final reason why he made his decision. Considering the undisputed evidence presented by the defense, undisputed in the sense that no one's arguing that there was a lot of TV coverage on this, the extreme nature of the news coverage in this case, and the small population of Leda, yeah, that's true. The defense has met the rather low standard of demonstrating a reasonable likelihood, I believe it's a low standard, that the prejudicial news coverage will comprise a fair trial in Leda County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. That seems like weak sauce to me. That is, a lot of people know about it. It's a small community. It's a low standard. I'm going to say there's presumed prejudice. That's one of the kind of get out of jail free cards I have on this. And I'm going to go ahead and play that card and get rid of this to another county. Now, here's the real reason. He talks a little bit about, because one of the reasons the prosecution objected to this was the inconvenience it would cause to the witnesses and victims involved in this case, because the witnesses, the law enforcement, the victims' families, everybody's located for the most part in that area. And now you want to move it a few hours away to another county. Won't that cause a lot of inconvenience? So he goes on to talk about that. But here's what he says. He says, the Leda County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial while also continuing to perform their day-to-day duties of patrol and responding to calls. And when I read that, I said, aha, okay. This is really kind of coming down to dollars and cents. And I like this judge. I think this judge made the correct ruling under the law. I agree with this for a reason that we'll talk about in a moment, but this is really the reason. They can't handle it. Similarly, Leda County does not have enough clerks to efficiently manage their jury selection process. We just don't have the folks that we need to do this. He goes on to say, the courthouse lacks the space needed by both the state and the defense. This is the reason, folks. They like all of that presumed prejudice, small county, big news, all of that stuff. It's really, get this mess out of here. It's too much for this county and this courthouse and these clerks and this law enforcement to handle. And then this was the one that I felt like was the real stick in the eye of everybody else. But he says, while traveling, this was the one. While traveling to another county for 3 months is indeed inconvenient for the attorneys, the court, some family members of the victims, and some witnesses. Having the trial at the Lake County Courthouse was also be inconvenient in numerous ways, and beyond that would present serious safety risks. So in other words, it's more of a headache for us than it will be for you. So we're going to go ahead and move it. Now, why do I actually have no problem with this whatsoever? Because it's a death penalty case. And this is about as serious as it gets. And I think in a death penalty case, it is smart for both the prosecution and especially the judge to kind of give it all deference to the defense where they can. I'm not talking about bend the rules. I'm not talking about break the rules. I'm not talking about, handing up a bunch of softballs for the defense to knock it out. I'm talking about when it comes to things exactly like this, issues that defense is making a big deal about, if you can address those and cut those off so those won't present issues down the road on appeal, then go ahead and do it. And I think that's the smart move. They're going to try this man and try to give him the death penalty, and that will create appeals for years and years and years. And every time they have an opportunity to eliminate one of those appellate issues, they should go ahead and grab it. And I think that's what they did here. Raven says, I heard someone say the judge didn't want the case. Might be true. I don't blame him. Looks like an absolute headache and an absolute mess. And he might be right, but I think he was given legal reasons and probably smart reasons to go ahead and move it to another county. And somebody said earlier, it's not going to change anything. And that's really what this comes down to. None of this, jurors, prejudice, presumed prejudice, all of that, they could get 12 jurors who just crawled out from under rocks and have never heard of this man in their entire life. And I think this is headed for the same exact place that it was always headed for. And that's a conviction, because none of this gets his DNA off of that knife sheath. None of this changes the tracking of his phone and that his phone was turned off, and the vehicle and all of the other evidence that we have seen building up in this case. The arrest affidavit in this case was remarkable with the amount of work that they did. I don't think this changes any of that. So yeah, you could try this in Lake County, Idaho County, any county, and I think it's going to be headed towards the same direction. Moving the venue doesn't necessarily mean that the judge is removed, right? It doesn't necessarily, but in this case, it does. In this case, he's asking to have it assigned to another judge, which my only concern for the victims and the victims' families and everybody else is, does that mean a new judge means further delay? Is a new judge going to be more inclined to say, I need some time to catch up on this whole thing, so I'm going to delay it further? I can't imagine so, though, because it's already pushed out to 2025. I think fall of 2025. If you guys know the exact date, let me know. I know I have it written around here somewhere. Kaylin, do you know? I'm putting her on the spot. She might know. But if it does, I just can't see that being enough time for the judge to get ready on all of it. Again, the judge doesn't need to try the thing. He just needs to have his head wrapped around it enough to be able to make decisions on it. Oh, thank you, Kaylin. Trial 6/2/2025. Plenty of time. Even on a case, a death penalty case, that's plenty of time to get this all together. All right. Wow. I've been talking a long time. Should we talk a little bit of Adelson? Are you guys down for that? And then maybe call it a night on our first Wednesday night live. I hope you guys are enjoying this. I hope you like the format. If you have suggestions on things you would like to see done differently, please let us know. We are a young and very humble channel, and very happy to hear your thoughts on how we could improve. And, let me do my quick plugs again. If you guys are new here and you haven't subscribed, please do subscribe. Again, please check out that membership program. We're very proud about it. Tiffany and Kaylin have been working extremely hard to make sure that we are not just kind of limping into it, that we're giving you guys a quality amount of new content and behind the scenes stuff and members only live streams and all of the things that we can to make it worth your while to support the channel. On that note, a couple of things coming up. One were our last case notes. We had to skip a week because, as you know, we had a baby. So again, I'm going to use that excuse for as long as I possibly can. But our last case notes was on Brian Walsh. This is the man who is accused of murdering and probably chopping up and then disappearing his wife so that her body has never been found out of the Boston area. We did a case notes on that. That's part of our series where we just do a deep dive on a case that's not exactly heading to trial just yet, but just so you guys can get caught up on it. And we have our newest release, which will be our first premiere release, will be on Monday on Donna Adelson. That trial is expected to start next Tuesday. I actually think it is. I think they have jury selection slated to begin on the 17th. So in anticipation of that, we did an entire episode on 5 things you need to know about Donna Adelson heading into that trial. Thank you so much, Jen St. Pierre. I appreciate that. So a lot of people have been following this case. It has been going on for forever. This is now what is it going to be? The 4th trial of someone involved in all of this. Everybody has been convicted and gone to prison. And so if you've been following this, you know how much there is about it. And we could have done a 6-part series on that case. But I thought, let's do something where it's just kind of some quick information for people who may not know everything about it. 5 important little nuggets that you need to know before you head into trial so that you can understand everything about it. And so that's the next one that we have coming out. So we plan on releasing that as a premiere on Monday, meaning that it will go live so that we can all comment on it. I'll be in the comments chatting with you guys, and then it will live on the channel for you all to watch. But on that note, just a couple of quick things to talk about with Donna Adelson coming up. And one of the things I thought was interesting was one of the 2 issues were handled towards the end here, which were kind of fundamental. The first was this issue about them trying to have the indictment dismissed, her defense team, Roshbaum. And the reason for that was that they called it a prosecutorial delay. And yes, do you think Wendy is next? I don't know, Cajun girl. I put it this way. I would not be surprised. Any other case, I would say I would be surprised. In this case, I would not be surprised. Certainly a lot out there. You're enough for you to go, I wonder why not. But I think the prosecution so far, I've got nothing but compliments for them for how they've been handling this. But to this issue about prosecutorial delay. Usually you do not see this problem. Usually there is something called the statute of limitations. And in most felonies, robbery, burglary, a lot of your big felonies, assaults and things like that, there's a statute of limitations. So the prosecution has, 5 years, let's say, to take it to trial or to charge someone. And that prevents the prosecution from taking too long because it's written into the law. Where that doesn't apply is in murders. Murders, as far as I know, in every jurisdiction in this country now, I know that some jurisdictions were holding on to an actual statute, but in most jurisdictions in this country, murder is unlimited. And that's why you see cold cases. That's why you see murder charges coming up from a murder that took place 10, 20, 30, 40, 50 years ago sometimes, is because they don't have a statute that they need to deal with. And it's the same reason that you don't see this kind of an argument come up much, where the defense is saying the prosecution just took way too long. Now, I am happy that the judge denied it in this case because I think that Ms. Adelson, Senior Donna Adelson, needs to have her day in court. I think she has a lot of answering to do. But I also think that the defense's argument here was not all that bad. What it essentially boils down to is hey, you guys had all of this years ago. You've been essentially just been doing, parts 1, 2, and 3 of the same case. All of this evidence, it's not like you discovered something new. Some witness came forward, some lab results all of a sudden are revealed. You're just now deciding to charge my client. And the reason that you did that was strategic, not for any other reason. And if the reason you did it was strategic, then that's prosecutorial delay because that actually prejudiced my client. And they pointed towards a bunch of things. There were, the cell phone records or oh shoot, what is the name of the Sun Pass records that they couldn't get? Because those things, we weren't able to get them at the time. Now we're in a worse position, and it's only based upon your delay that we're in that worse position. Somebody's asking about the closed door meeting on Adelson possibly testifying. I think it absolutely was about that. It was closed door. It was under seal, so we don't know, but I can't imagine what else it would be about but him testifying. He's on the witness list. But getting back to this issue, to me, it was a good argument. I'm not surprised the judge denied it because I don't think the judge he's a very good judge, but I don't think he's got it in him to just deny them to prosecute this case. But I think it was a good argument. I think we might see that argument come up later on an appeal because the prosecution did wait, and there isn't all that great of a reason for why they waited. So that was one issue. Afton asked, how long after the records were destroyed did the charges get filed? Well, the charges didn't get filed until, a week or so after Charlie was convicted when she was caught at the airport on her way to Vietnam on a one-way ticket. So from the murders till then is how long. I don't know when the records would actually be destroyed on some of this stuff, but they're saying, hey, when they made these first charges, and you could even argue when they charged Charlie, if you want to even be most generous to the prosecution, when they charged Charlie, they probably should have charged Donna. And why did they wait from charging Donna to charge Charlie? I don't see a reason coming forward that explains that delay other than what the prosecution is saying is that it was strategic. Now, the prosecution could say, well, there were conversations that he had with her while he was in custody and some other things we've learned of. Perhaps, I don't know, they've said now that they're not going to use those statements, but whatever. Putting all of that aside, I'm just bringing this up as a kind of stay tuned. You might hear more about this. But for right now, that has been denied. She's heading to trial. And the last issue that came up was this idea about the PowerPoint that was created by Tallahassee Police Department Sergeant Chris Corbett. And it's a 329 slide PowerPoint presentation on communications between the defendants that they plan on using and presenting during trial. And this was the last kind of point I wanted to make on this is the defense is objecting to it because they're saying we don't think that presentation should be actual evidence that should go back into the jury room. And I think the judge is going to grant that. And I think the judge partially did already grant that. It's not evidence. It is demonstrative. And so sometimes demonstratives go back into, can get marked as an exhibit and be used. Most of the time, no, though. The evidence is the evidence, the raw data. If you want to take that raw data and try to explain it in some sort of demonstrative form, fine, but you don't get the demonstrative because that's kind of seen as being argument, not the actual evidence. You get the actual evidence and you got to piece it together yourself. So that is kind of well taken to me. But what the judge decided to do is he's going to let them use it. He's going to let him testify as an expert to the extent that he can explain his findings from it as it explains this PowerPoint. But I think more than anything, what I love about it is that you just don't see this a whole bunch from prosecutors. These prosecutors are really good And what they're doing is they're doing their closing argument during trial. That's what it is. They are doing a very good job of not waiting till the very end to put it all together for the jurors, but to lead them through the whole trial. So that at the very end of this trial, those jurors will be able to give the closing statement from the prosecutor. That is a great way to put on a trial. And as much as you can possibly do it as any kind of an attorney, I think it should be done. And I think it would have been a mistake with all of this confusion and morass and web of evidence to try to then wait till the very end after they've tuned out and not paid attention to anything to then say, here's our beautiful PowerPoint presentation to explain all of that to you. Instead, they're saying we're going to use it during this person's testimony, which is going to make some rather dry testimony, now riveting testimony, to explain to them this connection that leads from Donna to Charlie to McBanois to Sigfredo and then back again. And that is really what this whole case comes down to, is connecting that arc back and forth is really what this case is going to be about. What about the older man, Harvey, her husband, Charlie's dad? He had to know something, right? I think he absolutely had to know something. He was part of these huddled conversations they were having. He's married to Donna. I can't imagine that Donna is going about conspiring for a contract killing and Harvey has no idea about what's going on. I can't imagine he's saying to himself at the coffee, at the breakfast table in the morning over their coffee and grape nuts that I don't want to hear about the murder stuff. Keep me out of it. That's between you and Charlie. You take care of the murder stuff. I have to imagine he knew, but the arresting officer or the prosecutor at the time made a very interesting statement that when Donna was arrested, he said that we had to move quickly and we didn't have evidence to arrest Harvey. So to me, that means one of two things: that either they just don't have evidence on Harvey, or they don't have it yet. But I think he's absolutely involved, and probably, if you ask me, between him and Wendy, who's got the better chance of getting charged, I would think it's him. Was the PowerPoint given to the jury in Charlie's trial? I do not believe it was either there. I think it was used, but not, or used, or something similar was used. But again, usually you do not see these demonstrative go back to the jury room, because they are argument. I mean, they're not objective enough. Where you do see it is where it's things like a chart that was created by the expert, which kind of distills different piece of evidence. I've done things like that in court. Cell phone records, you can kind of get like maybe one document can be marked and moved back, but a full PowerPoint, 329 page PowerPoint presentation, I don't think that's happening at all. Happening in pretrial. I think what's happening in the pretrial tomorrow is that the judge wants to hear a little bit more from this expert, Corbett, on how he actually compiled the PowerPoint, because I think he wants to know a little bit more about, is this just another visual representation of the raw data, or is this some sort of expert interpretation of the data? There's a difference, right? There's a difference between just kind of showing the same thing in a different way and easier to understand, and a difference between adding your own expert opinion and flair to it. Anyhow, all right, guys. Well, again, you have all been phenomenal for sticking with me tonight on this what's it, flagship on our first endeavor in sailing the Wednesday Night Live ship. I hope you enjoyed it. Please, please, please let us know in the comments or on our page if there's things that you want included or things that you want differently. What happens if Charlie gets called to testify? I know he's on the list. I just can't see it happening. I don't know how it would be advantageous to either side. But again, this case is one of those cases where everything just happens that you didn't expect to have happen. And I absolutely think that law enforcement is keeping tabs on Wendy Joanne. Yes, I don't think that she breathes without people hearing about it. I think that we'll go after Harvey next and save Wendy for last. She will be last word on this horrible tale. Maybe. I mean, you know, they got to keep selling tickets, right? You got to keep people, you got to keep cliffhangers and people buying tickets to the next episode. So maybe it will be Harvey, and then they'll save Wendy for the end. Just incredible. You know, talk about a career-making case. These prosecutors have likely been working on this and nothing else for the last several years of their career, and they're doing a phenomenal job. Oh, thank you, Jody, so much. We hope you enjoyed it. We hope you all enjoyed it. We hope you all will be back next Wednesday. I don't think I have any more announcements for you guys other than, of course, every Friday we have our normal episode of Courtroom Confidential coming out. Please check it out. Like I said, next Monday, we're doing that premiere on Donna Adelson. Please check that out. And then be right back here again for Wednesday when we will do another one of these lives. I hope you guys enjoyed it. And thank you again. Have a pleasant night. I'm going to go say goodnight to all three of the girls now. Take care, everybody.